American business is making great strides in trying to meet societal expectations. Many will nowadays say it's not just enough to be profitable, but it's how and with whom you do business and even how you look that's growing in importance. The workplace is changing, and a good deal of that is because of government regulation. American business has always had to comply with government in some form, and much of government is structured to deal with business. How well a business navigates the waters of governmental regulations can decide whether that organization survives or fails. Human relations is at the forefront in relations between the organization and the government, whether federal, state, or local. All three branches, the federal government, the executive, legislative, and judicial branches, have had profound effects on American business and human relations. Now, in my lifetime, we've seen how business responded to the civil rights movement and moving more minorities and women into desirable careers, increased workplace safety through the Occupational Safety and Health Administration, how organizations interact with our surroundings through the environmental movement, and even the massive tightening of corporate financial and accountability brought about through the Enron and Arthur Andersen collapses, resulting in the Sarbanes-Oxley Act. The President, as the nation's chief executive, oversees regulatory agencies responsible for enforcing our laws. Those agencies can even be instrumental in helping form the laws that Congress passes and will prosecute violators. The President has the authority to issue executive orders to deal with business-related problems, and the courts then interpret the laws and act as the final authority in making binding decisions. One of the key federal efforts affecting corporate human resources is the Equal Employment Opportunity, or EEO. The Equal Employment Opportunities Commission investigates situations and enforces EEO laws. The Commission also resolves complaints and issues guidelines of how to comply with employment laws. There have been numerous actions, including constitutional amendments and laws passed applying to equal opportunity dating back to the Civil War. At that time, we had the Civil Rights Acts of 1866 and 1871 that enforced equal property rights, contract rights, and the right to sue in federal court if deprived of civil rights. Another key federal agency is the Office of Federal Contract Compliance Procedures. Now, this agency enforces affirmative action laws, monitors plans to correct affirmative action deficiencies, and will take legal action against companies that fail to comply with the law. When we think of how the government deals with workplace issues, combating illegal discrimination and providing reasonable accommodation come to mind. The Civil Rights Act of 1964 did much to reverse earlier workplace discrimination. The act took giant steps to end discrimination based on race, color, religion, sex, and national origin. It wasn't that long ago that it was more the norm than the exception for businesses and owners to treat employees or job applicants unequally. We're still within a few generations of businesses posting signs such as "Irish need not apply," or paying certain employees more than others, even though those other employees did the same work and had the same amount of experience. Disabled workers would often be passed over altogether. More recently, we're seeing an end to company policies of putting older workers out to pasture. Not only are the laws changing, but we're finding that many people victimized by those earlier policies are valuable and even important contributors to a company's well-being. There's even the prediction that older workers, for instance, will be encouraged to stay on after reaching their traditional retirement ages in order to offset a shortage of younger workers entering the workforce. Since the 1960s, we've had a long list of laws intended to bring about fairness and open opportunities in the workforce. Now, these include the Equal Pay Act of 1963, the Age Discrimination in Employment Act, the Vocational Rehabilitation Act of 1973, the Vietnam-Era Readjustment Act of 1974, the Pregnancy Discrimination Act of 1978, the Americans with Disabilities Act, the Civil Rights Act of 1991, the Uniformed Services Employment and Reemployment Rights Act of 1994, and most recently, the Genetic Information Non-Discrimination Act of 2008. Over the years, we've seen governments step in to make sure businesses avoid unfair policies, that EEO policies are observed, and that firms comply with affirmative action. Government agencies and the courts have also stepped in to correct past discrimination. Now the flip side has been controversial though, in that we've also seen a rise in what's being called reverse discrimination, where previously victimized classes of people are now wrongly given preferential treatment. Government action has also led to a number of other provisions in the workplace. Now we have what's called reasonable accommodation, and employees' needs based on religion or disability have to be accommodated. In some cases that means adjusting work schedules, dress codes, making the workplace more accessible, and even restructuring some jobs. Sexual harassment has been one of the major human resource changes to be enacted within the past few generations. No longer acceptable to make unwelcome sexual advances to another. In the past, there were cases of extracting sex from someone in order for that person to get a job or an advancement within an organization. Over the years, it became accepted that such practices interfered with work performance and even created a hostile work environment. There are now laws to prevent sexual harassment. Businesses have responded by developing policies to forbid the practice. Employees are trained in how to recognize and avoid the behavior, and those employees who do complain can do so without retribution. During the late 60s and the early 70s, issues of workplace safety came to a head. There was growing concern about preventing accidents and protecting the health of workers in hazardous jobs. The federal result was the Occupational Safety and Health Act, or OSHA. Here in Washington, we even had a state version known as the Washington Industrial Safety and Health Act, or WISHA. Basically, those laws required a workplace to be free from safety and health hazards, that employees be informed about the hazards that they were dealing with, particularly hazardous substances, and that companies keep records of accidents and illnesses, and that national standards are met. The Occupational Safety and Health Administration is the agency charged with overseeing occupational safety and health. The agency publishes regulations, conducts inspections, and acts on enforcing compliance and prosecuting violations. Business has responded by incorporating a number of safety and health programs. Awareness programs are now the norm in organizations. Firms identify and inform workers on how to recognize safety hazards. There are training programs and incentive programs designed to make the workplace safer and healthier. The text also points to studies which show that such programs have been effective through a decline in workplace-related injuries and illnesses. Proponents argue that it's been a win-win for business and employees. The job site today is certainly a far cry from what it was even a century ago. Next, we'll take up analyzing work and designing jobs.